COVID, there's been an absolute bonanza, a huge takeoff in online marketing and direct sales, and that's specifically catered for because it is clearly one of the most intrusive forms of marketing. And then international transfers, where information is being transferred outside the country. Once again, our global era has made that far more possible. And then just a few sort of practical tips and steps that you can take in your businesses to comply and to make sure that you don't get caught up. We've obviously all heard about these very high-profile data leaks. Liberty had one, Discovery had one. There was one for Experian had one very recently, which I'm sure you all heard of. And these can be catastrophic, and you'll see that the companies have treated them as catastrophic. And that's exactly why you need to have proper measures in place to prevent that happening, no matter how large or small your business is. Just a bit of background. This act has actually been lying around for almost 7 years. Some of the sections were brought into effect almost immediately, particularly those sections that dealt with setting up the information regulator and just the administrative sections, but the actual substantive provisions that affect you and me only came into effect from July 2020. What it is, it's a legal framework, and it's based on the fact that every person has a right to privacy of information. That constitutional right then is balanced by other constitutional rights. There's a constitutional right that everybody has an access to all information that they require to protect their rights and further their interests, whoever that's held by. And on the other hand, there's a right to freedom of expression. So people who have information within the right, certain contexts are entitled to publish it based on the right of freedom of expression. And this act is an attempt to balance those rights to protect particularly private individuals from the misuse of information that relates to them. You'll see point 3 on this slide relates to the information regulator. The regulator is the administrative body that administers this act, that dishes out the penalties, that investigates complaints, and with whom you liaise in the event of a suspected breach. As we said earlier, the obligation, the most of the act, the substantive sections came into effect on July 2020. There are a few sections that have not yet come into effect. There is a window period of 12 months given to comply. So we all have now this period until June 2021 to get our house in order, to set up the necessary systems, which in true South African style means we'll all probably start looking at it on the 1st of June 2021. But I really recommend that you do this before. As I say, no matter how small your business is, you are processing personal information, and you need to get those systems in place, and the consequences can be quite severe if you don't. Information collected before July 2020, if you're holding information that you already have, if you're going to use that information from now, you have to do it in terms of the Act. Then, who is affected? It's a cliche, we're living in an information age. Information is a commercial asset. That's, businesses use information related to their clients' lifestyles, income, product preferences, their needs, and all businesses sort of base their business strategies on those factors, and they collect information for that purpose, and some of them sell information so that others can benefit from it. Now we're getting into the technical jargon. What is processing? Now, processing's got a very wide definition. So if in any way you deal with personal information, that is processing. So it's from the time that you go out to collect the information, where you get the details of your customers' name, address, products they're buying. You'll get probably get their bank account details or credit card number, and you'll then in all likelihood you will store that information so that you can use it for future transactions, use it for future communications. Then dissemination of that information, if you're going to be giving that information out further on to your suppliers so that they can produce products for you to sell on, or if your other people that you are supplying products to, who are then dealing with the public, and they want to know for whom these products were intended, and what type of customers would be buying these products, that would also be covered. And then any kind of transaction or any kind of use of that information for any internal purpose, such as where you might correlate to particular customers, or you might, if you're in the business of, for example, making deals like an estate agent or someone like that, and you're actually putting two people together, you are now combining the information of both of those people, and that is also within the definition of processing. So now, what is personal information? Well, more or less any information that can relate to a person is personal information. So it's their personal details, age, sex, birth, marital status, information about their health or affecting their health, their behavior, who they work for, who they communicate with, what they do on the weekends, contact details, and even things like political views, religious persuasion, any information that relates to a person. So it's incredibly wide. So you must not think that you don't deal in personal information. If you're interacting with the public in a commercial environment, you are collecting personal information. So now the term for that the Act uses for an individual to which personal information relates is a data subject. That's just the technical term they use, because it does not only apply to people, to individual people, it can apply in context to companies as well. Obviously, certain information that individuals have, companies won't have, but every company will still have a name, an address, banking account, etc. Then a responsible person is a person who is doing the processing. So if you process any personal information, you're a responsible person. If you contract that out, you can contract, if you contract any of those functions out to an operator, as it's called, you remain responsible. And you are responsible for ensuring that the operator also complies with the Act in respect of that information. Then the Act uses the term record. So any recorded information, so no matter how it's recorded, it can be in a book, it can be on a computer, it can be in any form where you're storing information, is a record, and the maintenance of records as applies in the Act is it will cover that, the way that you use that record. So in summary, if you process personal information, if you enter it into any record, any type of storage mechanism, if it's processed by or for a responsible party, in other words, if you're a responsible party, or if you are an operator on behalf of a responsible party, and the responsible party is in South Africa. So South African Act, it only applies to data processing that's going on in South Africa. We will see that it does provide for cross-border transfers in certain circumstances, but in those circumstances still, it's by people in South Africa who are transferring that information offshore, and how the Act affects them. Is there any exempt information? Well, not much, but the definition of a data subject does require that they be a living person or an existing company. So it does, this Act doesn't cover information relating to deceased persons. Obviously, you've got to be very careful if you're processing deceased persons' information, because by implication, that information may include information that will impact or be relevant to relatives and other former business partners who are still alive. So one's got to be careful to make sure that even if you think it's a deceased person's record, it doesn't actually include data that applies to a living person. Then de-identified information. So what that means is, if the information, for example, you have a record that says Ian Jacobsberg buys Coca-Cola, likes Coca-Cola, and will be in the market for Coca-Cola. If you take out that name, so that you will know that people are buying Coca-Cola, but it can't be linked to any individual, that is also excluded. The information regulator, we spoke earlier, that's an appointed body responsible for enforcing compliance, investigating contraventions of the Act, and receiving complaints. The regulator is also the person with whom a responsible party needs to communicate if you suspect that there's been a data breach in your organization, if there's been if you need assistance in managing a data breach. So what can the what are the regulator's powers? It can issue codes of conduct, which it has done some already, which can affect either a certain industry or a certain type of information or a certain class of consumer. They can conduct public hearings into breaches or into matters that might affect policy, and investigations into breaches. They even have the power to enter and search premises if they get a warrant, if they believe that there's been a breach, and they can issue enforcement notices. Those enforcement notices are important because that is when they take action, and if you don't comply with an enforcement notice, the consequences can be, there can be fines, there can be imprisonment, and other dire consequences. They can summon witnesses to their hearings in the course of their investigations. So then the Act does provide for a number of offences, most of which have to do with the actual procedure of enforcing the Act. And as you can see, there are, in serious cases, or there can be a fine of up to 10 million rand, there can be imprisonment of up to 12 months, or both. These are just some further offences and further conduct that might incur penalties. From the point of view of a private business, if you have a look at the last one on that slide, unlawfully processing account numbers, that is the only one of the activities that a private business might conduct that carries that kind of criminal sanction on a first offense. Any other offense, the regulator has to investigate and must have issued a compliance notice. If you then failed to comply with the compliance notice, then a criminal penalty may follow. But if you are unlawfully processing people's account numbers, then the criminal penalty can follow immediately. So then the Act prescribes 8 conditions for lawful processing. There they are, and we'll go on to look at them in detail. First one's accountability, and that all that really means is that every responsible party has to take responsibility and has to make sure there are measures in place to ensure that the information they process is properly managed, is secure, is not going to leak, and is not going to be abused. You'll see on the top line there, the head of a responsible party is automatically designated as the information officer. So if you are the CEO of a business, no matter how large or small, or if you're in your own business by yourself, you are the information officer, whether you like it or not. And ultimately, the buck will stop with you. Sure, you can have to be trained and you can designate other staff to take on certain responsibilities. But ultimately, the CEO or equivalent of CEO remains the responsible party. As we said, the information officer may delegate duties.
What you doing?
It may deputy. With no specific qualification, they don't even need to be an employee of the company, but they need to be designated in writing. So the person must be appointed in writing, whoever the deputies are, can be a term of their employment contract. And then all information officers must be registered with the information regulator. So as soon as you have appointed deputy information officers, both the CEO and the deputies must be registered with the regulator. The limitations on processing, it has to be, the emphasis is on respecting the data subject's rights and using the information for the limited authorized purposes only. So in general, the consent of the data subject would be required. So where you are dealing with people online and you have online terms and conditions, those terms and conditions should now include prominently a consent to the use of information that is provided. There are exceptions if there's no consent. If the processing is necessary to fulfill a contract, such as, for example, getting someone's address in order to be able to deliver products to them, protection of a legitimate interest of theirs, if you're rendering a service for them and you need that information to render that service, or compliance with a legal duty. So there may be cases where you are obliged to disclose information because you're under a subpoena or something like that, where there is a legal duty that you have to comply with. It has to be collected directly from the data subject. In other words, you can't go to a third party unless it's already public or the data subject has consented, or once again to comply with a legal obligation for court proceedings. Obviously, there's no problem and no obstacle to investigating events, affairs, for obtaining evidence if you need it for court proceedings. And that would be whether it's a civil case or whether it would be a law enforcement body that's doing it. It must be for a specific purpose. So the emphasis here is on informed consent. And when you are obtaining the data subject's consent, they must know why you're collecting the information and how you're going to use it. Continuing under that, under the heading of purpose specification, you may not retain information for longer than necessary. So if you obtained it for a specific purpose, as soon as that purpose has been carried out, you need to de-identify or delete that information. Then this is just a little graphic on which you can decide whether further processing it. And further processing is where that information is passed on to someone else for another purpose, or if you are even using it for another purpose. You may obtain information for a particular transaction, but then you maybe want to use that information to enter into another transaction with that particular data subject. And you've got to make sure that there's a close relationship, that the data subject understands that it was implied in the consent, and that there is a contractual right or obligation involved. The next requirement is the quality of information. So it is incumbent on the responsible party to ensure that the information itself is correct and accurate and complete. If you are obtaining information and you have some suspicion that may not be correct or it may not be completed, you have a duty to interrogate that and make sure that you're not transacting with a person based on incorrect or incomplete information. And even worse, if you're going to be passing that information on, that you're not passing on incorrect or inaccurate information. And you should keep a record of the information that you've corrected as proof, so that you have complied where you've come across inaccuracies. Then there's a lot of overlap certainly between these various requirements, but this is now the next requirement, that the responsible party must make sure that the data subject is aware of all the, if you want to call it that, terms and conditions around the collection of information. What type of personal information is being collected, where it came from, who it's being collected for and why, and then whether the supply of information is voluntary or mandatory. Some cases, a person may not, and you've all probably seen those drop down boxes where so you have to designate which information is absolutely necessary and which is not. Then, what are the consequences of the failure to provide the information? Well, consequences could be as simple as, well, if you don't provide your address for delivery, we can't deliver the product. That's pretty obvious, but in other cases, you may, for example, need a person's ID number in order to access or to render a service. And if they don't provide, or you may need their cell phone number so that they can receive SMSs updating them on products, or that they can receive the service if it's an online subscription or something like that. Whether it's authorized or required by law. So, for example, probably many of you in your businesses and in your personal transactions have come across FICA, and FICA obliges people to collect information. FICA, just for those who may not be familiar, is the Financial Intelligence Center Act. Every financial institution, attorneys for that matter, accountants, people who are collecting, who are entering into financial transactions with people, are required to collect information about those people, including their residential address, their ID number, and that's a requirement by law. And if you're a so-called accountable institution, then you have to collect that information. Then in terms of POPIA now, you have to inform your data subject that it is a legal requirement to obtain this information. And then the last condition is if you intend to transfer the information to another country. So for example, if you are procuring your product from another country and you have to send somebody's personal requirements, if a product is being custom made and you need to send a person's shoe size, clothes size, whatever it is, and it's going to be transferred cross-border. Then the important thing is to have measures in place. So that these are, and that it's important to actually then take professional advice, not only legal advice, but probably IT advice as well, as to how you can secure your systems to make sure that unintentional breaches or even hacking doesn't take place and that information is retained confidentially. And if you use an operator to process information on your behalf, then there must be a very, very tight contract in place to make sure that the operator is obliged to comply with the same requirements in regard to the data that you've collected and passed on to them that you have to your data subjects. If there is a breach, your first step, inform the regulator and the data subject. Those of you who've been following the Experience story lately will see that the regulators was informed very early on. Even if before you know the full extent, you should inform the regulator, and the regulator will then tell you what steps to take. And you, by doing that, you will have already covered yourself to an extent against the consequences, because you will have mitigated the damage as far as you possibly can. We've emphasized this before, but the data subject, the consent of the data subject is important. And in order to make sure that the data subject can exercise informed consent, they also have a right that at any time they can request access to the information that you're holding. And they can request deletions and corrections, as well as confirmation that you have it, of the type of information, and any third parties that will have access to it. As far as deletions and corrections are concerned, it goes without saying that the information that you hold must be correct. So a data subject can't simply insist that you enter something untrue in the record. So if it's that kind of correction that they need, you can refuse. But as long as if they are actually correcting the record, you have to comply. Then there's certain categories of information which are categorized as special personal information and to which special conditions apply. That relates to the type of information that people generally want to keep personal if they can, that they won't just share with the world and they won't necessarily share in business. And those are they. And as far as special personal information is concerned, it may, as a default position, it may not be processed unless, and then the first set of bullets there, you can see that the conditions are actually quite, the conditions there, the consent is always allowed if it's necessary for the establishment, exercise, or defense of rights. In other words, if it's needed for court proceedings or for some kind of administrative proceeding, if it's necessary to comply with international public law. Now that is not going to apply to most people in private businesses, but if between governments they need to exchange information or for diplomatic reasons, then that is one of the exceptions. And then processing for historical research or statistical purposes. So if you're doing it for purely academic type purposes, you can process that information. So if it's not for commercial purposes, and then there are conditions attached to that you have to de-identify as far as you possibly can. So if you're maintaining statistics, it's usually not necessary to keep names. It may be necessary to keep details of where people are located in a general sense, but you have to de-identify it to the extent possible. And then where it's already deliberately, and emphasis on the word deliberately, been made public. So if it was leaked by someone else, that doesn't allow you to republish it. Only where the data subject themselves has leaked it, knowingly, that you can. Then there's special exceptions for some of them in certain cases. Religious and philosophical beliefs, religious and welfare and spiritual organizations can process information relating to their own members or relates directly to their own activities and their own objectives. Information for the purposes of race or ethnic origin can be used where it's necessary to identify persons. And as much as we all try and be politically correct, if you're a witness in a criminal case, sometimes it is just the easiest way to identify a person is, and to describe them, is by reference to their race. The other situation where race or ethnic origin can be processed is for any kind of legislation that is aimed at redressing previous discrimination. So your BEE legislation, your employment equity legislation, which the aims of that legislation is based on race and redress of racial injustice. There, the processing of information relating to race is allowed. Trade unions can process information relating to trade union membership, as can the employers where trade union members are employed. Political persuasion, political parties and government organizations are allowed to process information relating to people's political persuasion. Information relating to a person's health or sex life, where it's required by a medical practitioner for the purposes of a healthcare service that they're rendering, it's permitted. Medical schemes, insurance companies, and the like are also allowed to process that type of information where it is relevant to them for assessing risk. And then lastly, criminal behavior. You're entitled to process criminal behavior. Firstly, obviously the state can in the course of law enforcement, and then with very strict conditions, criminal behavior where it is relevant for employment purposes, and on condition that it is destroyed or de-identified as soon as possible after it's been used for the necessary purpose. Children also have special protection under this Act, and personal information relating to children, as a general rule, can't be processed subject to the same conditions that we saw apply to special personal information. You'll see in those bullets, there is the term competent person. So a competent person is what used to be called a parent or guardian. The Act uses the term competent person. It's any person who is entitled by law to give consent on behalf of that child. Then the effects on direct marketing, the Consumer Protection Act already has quite detailed stipulations related to direct marketing. And POPIA takes it a few steps further. You'll see there, because personal information is a significant commercial asset, they've put these measures in place to make sure that consumers are not subjected to harassment and intrusion, and, as we all know, and as we all know, and I think we all have been at times.
Ian?
Opt-out is that you will receive communications unless you object. Now, under the Consumer Protection Act, there's actually a register, an opt-out register. So you can actually put, which is maintained by the National Consumer Commission, you can put your name on that opt-out register, which then records that you are not prepared to receive unsolicited communications in respect for direct marketing purposes. Opt-in is, as it indicates, the opposite, where you cannot be approached unless you have indicated that you're willing to be approached. The implication of that is that you will need to obtain consent from your customers. There is a distinction drawn between new and existing customers. The existing customers, where you already have their information on record, you can continue to use that information with this condition that they can opt out at any time. New customers are subject to the opt-in. So they will only, you can only approach a new customer or use information or process information if they consent to it. So you can obtain that prior consent, provided that the data subject has been allowed to opt out if they want to. Otherwise, they can consent, and that has the effect of an opt-in. You'll see the second last bullet point there. The information must be collected for marketing the responsible party's own products or services. So you can't trade in personal information. If you're collecting information relating to your customer, you can't pass that information on to someone else who may also want to market their product to that customer. So from a practical point of view, what do we recommend? That you contact, or if you have existing customers whose records that you are holding, contact them and ensure that they do have consent. Or you could continue to market and advise them that they may opt out. Now we deal with international transfers of information. As a general rule, you cannot transfer information to a destination outside South Africa unless the person that you're transferring it to is subject to rules that are similar to POPIA. And it's not sufficient that they just have a data protection law. They just have, the law must actually, and so you've got to investigate professional advice from practitioners here and across the border. Then you have to be sure that there is that there is an equivalent law. There was a case in Europe based on their data protection law, which is called the General Data Protection Regulation, where the court actually went into great detail in relation to a US law providing for data protection, and eventually came to the conclusion that that particular US law, remember the US has different laws in different states, so it won't apply. The law didn't provide the correct measure of protection. Check where, if you are transferring information outside South Africa, check where you are and get advice. Make sure that they have adequate protection and keep records in case you do have to account to the regulator. Then for practical steps, well, as we said earlier, you have until 2021. It's important to take this time to put processes and procedures, both technological, such as passwords, restricted access, automatic deletion, and then also by way of training your staff and enforcement. In other words, discipline staff who are not meticulous about the way in which they handle personal information. The policy must be clear, the policy must be accessible, and your staff must be well aware of it and well aware of the consequences if they don't follow it. We spoke earlier about deputy information officers. Make sure that you do have at least one person who is designated as an information officer and who takes responsibility for ensuring that the rest of the organization is compliant. Something that companies, both large and small, are currently starting to do is a risk assessment, where they're starting to actually do an audit of all the personal information that they're currently holding. Make sure that they know what they have, they know where it comes from, and they know how they are complying, and they know how they are looking after that information. So here, some more steps. All emphasizes on training, on transparency, on security. All of these things are things that need to be looked at. So that is the theory, and that is the law. I'm available to take questions. I don't know what came in through the chat or verbal questions. I know it's all quite daunting stuff. I think that we have this window period, and I think the closing message is that we all need to, and that includes lawyers, who keep a lot of personal information. We all need to make sure that we're compliant, and we all need to make sure we've got those systems in place.
So Ian, I have a few questions. The first one was, does the Act cover company data such as directors, bank account details, etc.?
Yes, it does. A company can be a data subject to the extent that it has, or that any of its information falls into the category. Definitely bank account details. Details of directors are matters of public record. So for example, so you can go to the CIPC and find out who the directors are. So that wouldn't be a problem. But other information relating to the company, such as bank accounts and perhaps details of employees that are not directors, would also fall into that category.
Okay, and another question. So generally within the law, records are kept for 5 years. Does this include personal data collected for the purpose?
Well, there is no specific period in terms of POPIA. The records that are kept, those other whether it's in terms of the Companies Act, whether it's in terms of tax legislation, those statutory retention periods will still apply to information that they cover. As far as POPIA is concerned, the period is only as long as the information is relevant and is necessary for the purpose. So if that's less than the 5-year period, but there's another law that says you have to keep it for 5 years, you keep it for 5 years. If it's more than the 5-year period, then you can keep it for more than 5 years and destroy it as soon as it is no longer necessary.
Thank you. And another question, if we receive information for a third-party client, are we allowed to accept it?
When you talk about a third-party client, I'm not quite sure what the question's getting at, but if you receive...
Dan, can I say what I mean? If we're working with a client and they want us, they have a client base.
Yes.
They then want us to communicate with their client base for them. Are they allowed to send us that database and we use it on behalf of them or not?
Yes, you are then becoming what we spoke about as an operator. And they remain responsible to their customers, but you are then entitled, if you have a contract with them, and you've undertaken in your contract to do certain things on their behalf, that contract should then also include a term that you will respect the personal information of their customers.
Thank you. So the onus is on them, basically.
Well, the onus is, yeah. I mean, once you've taken that responsibility on, in terms of the contract, you are also, as the operator, responsible. But the onus is on them to put that in place. But if you as the recipient, as the intermediary, are receiving it, it would be responsible to go back to them and just ensure that you do have the correct consents and that they have the correct consents.
Thank you.
And I have a question from Ryan. He says, with regards to point 3, in terms of data specifications, if systems hold customer lists to get paid